Hello students, let us continue our exercise on legal principles. So the next principle, 12th principle says, every agreement of which the object or consideration is forbidden by law is unlawful and hence void. Fact, A agrees to let her daughter be hired for prostitution for rupees 1000. So C would be the answer. The agreement is void as it is immoral and is also forbidden by law. Principle. An agreement, the meaning of which is not certain, are void. So, fact. A agrees to sell to B 100 tons of oil. What would be the answer? B would be the answer. The agreement between A and B is void for uncertainty because there is nothing whatsoever to show what kind of oil was intended. Next. 14th principle says an agreement to do an act impossible in itself is void. Fact. A agrees with B to discover treasure by magic. Answer would be C. The act is void because the agreement to discover treasure by magic is impossible of performance. Impossible to be performed. And that is what the principle is saying. So if we match the catch, it says that agreement, impossible, void. Discover treasure by magic, void. So the act is void because agreement to discover treasure by magic is impossible of performance. Simple. So the next principle, 15th principle says, whoever by words either spoken or written, by visible representation or otherwise, brings or attempts to bring what? Hatred or contempt, or excites or attempts to excite disaffection regarding government established by law in India shall be punished with imprisonment for life, to which fine may be added. So fact says an environmentalist, Vishnu Partikar, in a public meeting enraged on the environmental policy of the government and gave a very hot speech. He said, this is the government of fools, scoundrels and scamsters. Teach them a lesson in coming elections by voting them out of power. Vishnu Partikar is being tried for sedition now. So what would be the answer? A would be the answer, that Vishnu Partikar is guilty of sedition for having made irresponsible and inflammatory statements against government. 16th. Whoever intending to take dishonestly any movable property out of possession of any person without that person's consent moves that property in order to such taking is said to commit theft. So there would be a dishonest intention and without the person's consent. Okay. So Amir with an dishonest intention to take Samir's dog puts a bait for dog in his pocket. On noticing bait, dog started following him. Later on, Amir found a gold chain tied in dog's neck. So B would be the answer. Amir committed the theft of dog as well as gold chain because chain was attached to dog. Next one. Principle is same. The principle is again says, whoever take dishonestly any movable property without person's consent moves that property in order to such taking is said to commit theft. So here Raman gives his coat to XYZ dry cleaners for dry cleaning. He wants to put this on the occasion of his friend's marriage. On the day of marriage, when he reaches to the dry cleaning shop, he finds that he has forgotten his purse at his place. As he was getting late to the marriage, he surreptitiously places coat near his bag and takes it without the knowledge of the shopkeeper. Now Raman is, option C would be the right answer, that guilty of theft because he took the coat dishonestly and obviously without the consent of the dry cleaner. So principle is, whoever causes the death of any person by doing any rash or negligent act shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or both. Okay. Sunita, a woman was boarding a DTC bus from the front entrance. The conductor whistled and the driver took off bus immediately. She fell off and was crushed to death by rear wheel. Driver and conductor both were prosecuted. Answer would be A. Both driver and conductor are guilty of negligent and rash act. Principle. The same principle would be applied here. So let us again see the principle. Principle again says, whoever causes the death of any person by doing any rash or negligent act shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or both. Let's see. A boy entered into the swimming pool of country club surreptitiously and without notice of Chowkidar Ramu. He was lost in water. Secretary of the club Vinayak and Ramu were both prosecuted under rash and negligent act. Now, C would be the answer. Simple, that no one is guilty of negligent act because boy entered the club surreptitiously. The same principle, we know the principle. Let's start the next fact. Bittu, a compounder, in order to make up a fever mixture, took a bottle from a cupboard where both poisonous and non-poisonous medicines were kept, and without reading the label of the bottle, which was in wrapper, added it to the mixture which was administered to Ram. Ram died of poisoning. Later it was found that the bottle was marked poison. Now Bittu is answer B. Bittu is guilty of negligent act because he should have read the label of the bottle. The next principle, to create a contract, there must be a common intention of the parties to enter into legal obligation. There should be a common intention, and common intention of what? To enter into a legal obligation, that we will perform our promise. So A and his wife were enjoying leave in England when A was due to return to Ceylon, Sri Lanka, old Sri Lanka, where he was employed. His wife was advised to stay back in England for health reasons. Now A then promised to send her an amount of 30 euros a month for the probable expenses of maintenance. He did send the money for some time, but afterwards differences arose and he stopped sending the money. Whether A has entered into a binding contract with his wife or not? No. B answer. No, because common intention of the parties was not to enter into a binding legal contract. It was just a promise between husband and wife. Same principle now. I know what you all are thinking. So the next fact will give your answer. The same principle. Now a husband and wife withdrew their complaints under an agreement by which the husband promised to pay her wife an allowance and the wife refrained herself from pledging his credit. There is an agreement, binding agreement, and that too in front of court. A would be the answer, that this agreement is a binding contract and there was common intention to enter into a legal obligation. So the next principle says, an offer need not be made to an ascertained person but to world at large, and contract is made only with that person who comes forward and performs the condition of the proposal. So offer is at large and the contract is specific, what the principle wants to say. So the fact is, a company manufacturing smoke balls offered by advertisement to pay 100 euros to anyone who contracts the increasing epidemic influenza, colds or any disease caused to taking cold after having used the ball according to printed directions. So the fact says that a company says that if you take our product according to the prescribed form and then you catch the influenza, then we will be liable. So this is the fact. This is what the fact wants to say. So now the B used the smoke balls according to directions, but she nevertheless suffered from influenza. Whether B will able to get 100 euros? Yes. C answer, because she has performed the conditions of proposal. Thank you.